Welcome to SLO County Public Policy and the Law, only on K-News FM 98.5. This is lawyer Stu Jenkins. The Superior Court has repeatedly appointed me as special master to serve search warrants for documents and determine if the documents must be sequestered from investigators as attorney-client or medically privileged matters. Both Republican candidates and the Democratic Party have engaged me to represent them in election law cases. One of those was upheld 9-0 by the U.S. Supreme Court. I am pleased to say we have an important guest today. Assistant U.S. Attorney Mack Jenkins is a prosecutor who has successfully jailed dishonest and corrupt local office holders in Southern California. If you know a local office holder, be sure he or she listen. Phone them now or let them know that the podcast is available at knews985.com. That's KNEWS985.com. Mack Jenkins was head of the Civil Rights and Corruption Unit with the Department of Justice in Los Angeles. He is now chief of the Criminal Division of the U.S. Attorney's Office in Los Angeles. He was the prosecutor in charge of the investigation and the indictment in the Hill Dayspring bribery case some years ago. Welcome to the show, Mr. Jenkins.
Thank you, Mr. Jenkins. It is a pleasure to be with you on the phone.
Well, and I suppose I should let our listeners know that you and I are not close cousins. Can I call you Mac?
You can call me Mac. That is great.
Great. Okay. And you can call me Stu.
Great.
Now, one of the things I like my listeners to know is a little bit about my guests. You are an accomplished federal U.S. attorney in Los Angeles. You've done a lot. I've been following your exploits for years. How did you get in? Where did you go to school? Where are you from? And how did you get into the Department of Justice?
Sure. Thanks again, Stu, for having me. These are topics that are near and dear to my heart, not just talking about myself, but talking about impactful public corruption prosecutions in particular that really shape and restore our public's trust in democracy. At least that is the goal we are shooting for. So I'm from Southern California originally. I grew up mostly in Irvine and Long Beach. Both my parents grew up in Long Beach, in very low income, impoverished areas of Long Beach, but were successful enough in school to get academic scholarships to then a fledgling school in Irvine called UCI.
Oh, yeah.
And so I grew up, thankfully, in the pristine environment of Irvine, which was routinely ranked one of the safest cities in America at the time. And that stood out to me because whenever I would travel home to where my father grew up in Long Beach, it was a very different place. Different community, different interactions with law enforcement, different respect for politicians. And that contrast always stood out to me early on, basically sort of the inequities of where someone grows up or who's in charge of the police or who's in charge of the elections that affects so many people and so much of the community. My father, who always wanted to be a lawyer, always wanted to be a judge, and I think he would be awesome at both. But he had me and my two brothers, along with my mom, at an early age at UCI, and had to essentially start working early. So my dad ultimately started as a line probation officer in Orange County, and rose up to be one of the first Black chief probation officers, ultimately retiring in San Diego County.
Wow.
And so early on, just a sense of justice, a sense of engagement with community and public service were, stamped early in my life. I went to UCLA for undergrad. There I decided, after a brief foray as a walk-on the UCLA football team, decided that football was not in my future. And so
it was a much more fun contest.
Yeah, it was. When you get to college and people are twice your size and run twice as fast as you realize that your athletic career may need to take a detour. I was always very invested in the justice system because of my dad and growing up and seeing what he had gone through, including the civil rights movement and other really transformative parts of our history and justice. And I did really well on tests. Luckily, it's something that my parents blessed me with. So I was able to get into Yale Law School, which is really known, frankly, for its public service. And when I was at Yale, the idea of what a federal prosecutor is, which many people don't know, they know about DAs and see LA law on TV, but many people don't know what a federal prosecutor really does. And once I learned, what they do is really ideally prosecute people, the most powerful, the most sort of can't touch targets, and really shape, the criminal justice system and, again, people's trust in it. Ever since I learned that at Yale, I wanted to be an AUSA, which ultimately I became in 2000.
One of the things that you've been talking about is the burdens that are put on the public by corrupt office holders when they sell their official actions. What does that do to them?
In a place like the United States, who has this lofty goal, in some people's minds, success of being a democracy and government that other countries want to live up to, want to idolize, when we falter, particularly in a significant way, when a public official is doing something for his or her personal benefit rather for the constituents, it really shakes, if not shatters, our community's vision of our America, an America that, again, not holds just a significant place in local communities, domestic communities, but also worldwide. So we view every public corruption case, potential prosecution of political corruption, very significant, not just for that individual and that individual crime, but what it really does to the fabric of people's trust in our government.
Now, when I look at some of the indictments that you have been able to obtain from grand juries, there's discussion of wire fraud, depriving the public of honest services, bribery and rewards for official actions, and obstruction of government investigations. Are there different statutes, federal statutes, that apply under those circumstances?
Yes, although there's definitely a lot of overlap. The ones you listed, both wire and mail fraud, which is essentially a broad federal statute that we use in a variety of fraudulent contexts, from people ripping off people for money, defrauding people in business deals, but also one of the things you mentioned, defrauding the public of the honest services of its elected official, which is its own statute, 18 USC 1346, but it basically means bribery, which itself is also a separate substantive federal statute, 18 USC 666.
Well, I think of that one as the devil statute.
It is pejoratively called that sometimes, but it makes it easy to remember. Frankly.
Sure.
And there's other related statutes, things called the Travel Act, where if you violate a local law, a state law, but there's some interstate nexus, you traveled, you engaged in bribery in Las Vegas, but you traveled from California to do it, or there's a California component of who got paid or who paid who. There's other aspects that criminalize and protect, where we can utilize violations of state law and federalize them.
Well, now that brings me to one of your 2023 cases. There was this caught my eye. A Nebraska Republican Congressman, Jeff Fortenberry, was prosecuted by you for basically corruption. And I was wondering, how did a Nebraska Republican congressman end up snared in the Los Angeles Attorney's Office prosecution?
Well, you, Stu, and also the Ninth Circuit Court of Appeal also had that same question. And ultimately, when they reversed all his convictions and told us we had to do it over again somewhere else. So we actually recharged him in the District of Columbia,
wow.
Which is ongoing right now. So I'll be limited in my comments, except to say what we argued before the Ninth Circuit, less successfully than we argued in the district court. Factually, what happened is there was an LA-based fundraiser, and Mr. Fortenberry was alleged, and we have alleged that at that fundraiser he received tens of thousands of illegal foreign conduit contributions. Foreign being it's illegal for any foreign national, non-U.S. citizen to donate to any U.S. election in any way. And in addition, a conduit contribution prohibits someone basically from making a donation in the name of another, as to sort of conceal who's the real donor, or in some cases to circumvent campaign contribution limits. The allegations that Fortenberry's campaign in LA, while he was president, received such illicit money, and that he later obstructed and lied about it to LA-based prosecutors, LA-based FBI agents as part of that investigation. So he was charged with obstruction-related offense related to an LA-based investigation.
Interesting. Okay. Well, and I also noticed he raised as a defense, if I want to be accurate here, as I understand it, he was convicted here, but the conviction's been overturned and now it's being retried.
Yes, it is being, so it wasn't reversed on the merit, as we say, it was reversed on procedural. Basically, it should have been charged somewhere else.
Somewhere else.
He did that in the District of D.C., and the reason there is because he's charged with false statements and a scheme to falsify and obstruct a federal investigation. But we interviewed him, I interviewed him in the District of Columbia. So the Ninth Circuit ruled that is a proper venue for that prosecution.
But right before he was convicted here, even though that's been overturned, I noticed he made a motion that you were somehow being partisan in your prosecution. And does partisanship come into any of these prosecutions?
Only in the sense that any public prosecution, any public corruption prosecutor needs to be aware that that is often the first line of defense. Anytime you charge a political official, they're going to say it's political because of their political views or their political party. So as a public corruption prosecutor now for a long time, one of the things I empowered my people to say and do is, number one, check yourself. Make sure that that has absolutely no place in our decision making, and you should be aware of your own implicit bias. And the upside of that is what I often tell them. One is look at the resume of our office. Frankly, I have prosecuted many more Democrats in my career than Republicans.
Oh, yeah. The same year you prosecuted a fellow I met at many Democratic conventions, Mark Ridley Thomas, and got a conviction.
Indeed. And so that is, I don't know if you read the opposition, but that is one of our points, is that it's just, I would say, to put it diplomatically, not an accurate characterization of the facts of the history of our office or me personally.
Okay.
Second, what I tell our prosecutors is, while it should have no place, partisanship, obviously, in any meaningful criminal justice decisions, you cannot be afraid of those accusations, because actually it is worse to not prosecute someone because you're a fear of that you're going to be attacked personally or professionally, that you're doing something untoward or partisan. And if you bow down to that sort of anticipated attack, that's worse than actually prosecuting someone for partisan reasons or political reasons. The reason being is, if I present a case to be prosecuted and say I'm a member of the Green Party and I really want to prosecute anyone who's, whoever the rival of the Green Party.
Yeah.
There are a lot of checks before I can do that successfully. My supervisor, although as a criminal chief, it would be myself, but previously the criminal chief would supervise that. The agency heads would have to approve in the investigation. You present that case to a grand jury who has to return an indictment. Then you have to survive a judge and a motion to dismiss. If that happens, then there's a jury where you have to convince 12 peers beyond a reasonable doubt of the person's guilt. So really, there's a lot of checks on the process. And if the person is guilty, then they will be appropriately proven guilty regardless of your intent. Where the opposite is true is, if I wanted to bury an investigation because I was afraid that someone say Mack's being partisan, and you know what, I'm afraid of that. I don't want to get that accusation. So I'm just going to not prosecute a case. There's not as many checks to let that happen. So all that would do is then empower the corrupt people and empower that defense, and everyone would use that defense to protect the guilty. And so part of it is being mindful, but also not cowed by accusations that, one, are inaccurate, but two, we can overcome and should overcome and not be afraid, because otherwise that would just embolden those who are engaged in that conduct.
You've had a lot of activity in the city of Los Angeles recently. It seemed to me that you had a number of convictions, your office did. In 2022, there was a whole investigation of the LA Department of Water and Power. And what kind of corruption was going on there, and how did it come to light?
Sure. It was actually amidst when we were prosecuting what we called Operation Casino Loyale, which related to LA City Hall and City Council, and ultimately Jose Huizar and Mitch Englander, former council members who we charged and convicted for racketeering.
Right.
Around that same time, we got I won't get into too many details, but a referral from a defense attorney who said that he or she was representing an individual who wanted to report, had sort of seen what we're doing with City Hall and wanted to report some other criminal or suspicious conduct. And essentially, an individual came forward to report that corruption he perceives between the city attorney's office and its then special counsel, Paul Parody and Jack Lansgroner, related to essentially lawsuits against the city by individuals who were financially wronged related to a billing scandal and the LADWP's billing errors that caused a lot of inflated bills and other consequences. There's a big lawsuit. But the allegation was that the city had colluded with the plaintiff's attorneys who were opposing the city to rectify this harm. And in order to sort of minimize the damage to the city, both politically and financially, the two sides colluded by sharing in money between the lawyers. So they split a payment in order to make this sort of go away or do it more under the table. And so this individual came forward with that information.
So some of the public officials were actually taking a cut, it sounds like.
Allegedly, the lawyers.
The lawyers.
Ultimately did not connect it to any public officials, but the allegation was that the lawyers, the public officials had chosen. And ultimately, Paul Parody pled guilty to that offense. He was then the special counsel for the city and who admitted to be involved in a bribery scheme with Jack Landskroner.
Well, and didn't Jose, I don't know how to pronounce this last name, Huizar, didn't he just get 14 years?
Yes. So that was our Operation Casino Royale, which was a separate preceding investigation related to development in downtown LA and bribery and of pretty much every kind you can imagine. And then the city attorney's office, LADWP, corruption scandal, if you will, was a related but separate investigation.
You know, if you've got a public official who's noticing something going on locally, is there a way they can contact either your office or the FBI in order to report something that is corrupt?
Absolutely. One, there's literally a tip line for LA. It's the FBI has a tip line that is actually monitored and regularly checked, 310-477-6565. That is the FBI tip line. There's also TIPS@FBI.gov. And these are, again, monitored databases and where they get routed specifically based off the nature of the complaint. Otherwise, people contact the FBI or their local official who many people have relationships. We have relationships with people at different entities. So we often encourage people to reach out to the U.S. Attorney's Office. And Lindsay Greer-Dotson is the head of our public corruption and civil rights section now. I'd say regularly gets concerned calls and emails from people wanting to report.
Okay. So that's 310-477-6565 for the LA tip line.
Correct.
Okay. Now, the Central District of California is a giant district. If we were on the I think if California was flipped over on the East Coast, there'd be 17 federal districts, courts, and, of course, the federal attorneys with each of those districts. What counties are included in the Central District that you cover?
It's a good test question, Stu. Hope I did my homework. But, yes, as our first assistant likes to say, we are the biggest geographically of any U.S. Attorney's Office in the country, and like you said, by a major margin. And so the 7 counties include Los Angeles, Orange County, Riverside, San Bernardino County, San Luis Obispo County, Ventura County. I lost track, but I think I'm near 7.
I think Santa Barbara and Kern.
Santa Barbara, yes. Kern, I think, actually is in the Eastern District.
Oh, is it? Okay. Okay. Well,
I think so, yes. I believe that is right.
I'm thankful for that because that means we're the farthest north from you.
Yeah, I usually say from right north of San Diego to through San Luis Obispo. That's how I usually cover it. Then I got to remember the ones that.
Well, that's all right. That's all right. They don't count. It's just us and you guys. I did want to get to some of the local cases that you all have been working on, and I think the one that has gotten the most attention in our county is the Adam Hill and Helios Dayspring prosecution. And of course, Adam Hill didn't survive to be prosecuted. We're going to have a hard break here coming up in about a minute and a half. But how did your office get wind of the corruption that Adam Hill seemed to be generating or that surrounded him?
Sure. I think one of the benefits of being a smaller community, smaller town is people talk a lot. So we had a very diligent FBI agent team that covers San Luis Obispo specifically, and they work closely with the local district attorney. And people hear stuff and investigate things. And to put it at a high level, then Supervisor Hill's name came up a lot in conversations with people that put him on our radar. And ultimately, as is often in corruption cases, there's a paper trail developed, suspicious vote, unexplained money, and then ultimately insiders provide us information to either benefit themselves in their own criminal case, or sometimes whistleblowers who are sort of fed up with the corruption of local politics. Sometimes, frankly, it comes with political rivals that have good information. So we always consider the source, but sort of many of those factors came into play with.
You mentioned that some people gave information because they wanted to make their criminal prosecution less burdensome on them. Did you have a lot of witnesses like that?
I don't know about a lot, but there's certainly a handful who ultimately either become involved in or aware of activity that could potentially subject them to the attention of the FBI. And often when that happens vis-a-vis a subpoena to one of their companies or a business or a door knock from the FBI, it seems as a wake-up call, particularly in smaller communities. And typically, not always, they want to do what's in their self-interest, which is often to come clean and tell what they know.
Sure.
In hopes of leniency, even if they've not been charged or not sure they should be charged. Often the public officials want to appear as if they have nothing to hide, and then telling us information they have is sort of in service of that.
Were there any other prosecutions that arose out of that where somebody struck a deal to provide information and thereby were not prosecuted?
Not prosecuted will be harder off the top of my head, but okay. I would say almost all of our corruption cases rely on an insider who has either come clean because we've knocked on his or her door, or sort of the walls are closing on that person, and then they want to resolve their case as amicably and efficiently as possible in order to get leniency at sentencing. That's the most typical way, meaning that ultimately they still get a conviction and some sentence of some kind. Uh-huh. But I'm sure there are scenarios where we opted on close calls to not charge someone if both their conduct wasn't so egregious that we couldn't not charge them, because doing so would undermine the integrity of our prosecution against the others. And so it's always balancing sort of what is fair, how it will appear to a jury if someone is not charged. But at the same time, we very much want to incentivize people to come clean before we knock on their door, issuing them a subpoena.
Sure.
And there definitely have been cases where that has happened, and we've opted not to charge the person at the end of an investigation, which resulted in what we think sufficient justice elsewhere.
Now, when you talk about sufficient justice elsewhere, I'm old enough to remember when Vice President Agnew resigned in order not to go to jail. Have there been any public officials in San Luis Obispo County or even in Santa Barbara County who, with the Helios Dayspring prosecution and the Adam Hill investigation, resigned their offices in order to avoid prosecution? So
I can't talk about too much about our investigation that isn't public.
Okay.
So to try to answer it as informatively and boringly as possible, typically, if they just resign, that's something we would take as mitigation at sentencing, not charge them.
Okay.
So if we felt their conduct was corrupt enough for a felony federal prosecution, simply resigning would typically be insufficient in my eyes to mitigate that damage. And so usually they would have to do a lot more in terms of cooperating, testifying, pointing us to other information.
They'd have to have provided you a lot of the testimony and evidence that you could then use to obtain a conviction.
Correct.
Okay. Were there any instances like that?
There were certainly...
I'm not asking for names. I'm just curious.
There's definitely parts of the investigation that are not public that I can't comment on.
Okay.
And we certainly talked to a lot of people in the Hill investigation, in the Dayspring investigation, and then later in Ryan Wright, who's also, I believe, a lawyer up there whose prosecution is ongoing by our office. I think it goes by, Ryan Wright Belcher is the company.
Yes, Mr. Belcher used to be just down the hall from me. I was very surprised when I saw the stuff come out about him. That's too bad.
It is unfortunate, and still, I think, still allegations. So I think he's still pending trial. But
yeah.
There are certainly people we chose to charge based off the evidence, and there's always decisions to not charge people based off the evidence and based off their cooperation. But typically it's evidence-driven, and in the cases you described, I believe we identified the most culpable people for whom we could prove a criminal case beyond a reasonable doubt,
okay,
which is ultimately the Justice Manual standard that we follow.
What are the things, if you're a public official, because a part of the reason I wanted to have you on was so that, people, what is it in the Lord's Prayer? Lead me not into temptation.
Yep.
And there's a lot of temptation in public office.
Sure.
What are the things that people should look out for to avoid if they're in a public office to to make sure that Mack Jenkins and his team don't come to town and decide to prosecute him?
Yeah, it's sort of what I tell my prosecutors, frankly, in our job, because we have a very august, important, powerful job. But that doesn't obviously make us God or omnipotent. But it sometimes makes all our jokes funny, and everyone wants to talk to us and be our friend. But you can't let that be the measure of how you do the job. And so, both as a politician and as a prosecutor, sometimes, often we make very, very difficult decisions that aren't about making people happy, but about doing justice or doing what's right for the constituents. But if you get too caught up in wanting to be a people pleaser, or you like the adulation or the attention, I mean, I'm a federal government employee, and I really like the Lakers. My dad is a big Lakers fan. But if someone's going to keep offering me, front row seats to the Lakers, at some point I'm going to think this person has an agenda, which is people, in particular in Los Angeles, but in other towns too, often do. So unfortunately, in some ways, politicians need to be more jaded, or try to say it diplomatically, less believing that sort of how I said it, every joke they say is funny or they're always right. But sometimes maybe someone has an agenda when it appears that they're being too friendly or too generous. And ultimately, power is corrosive and corruptive. And it's true for prosecutors. It's true for politicians.
Yeah, a lot of the issues that come up in local government have to do with issuance of permit.
Yes.
And of course, the folks who are asking for permits frequently have, they have a lot of money on the line. And is that where you see most of the problems for local public officials arising?
I'd say that is the most common. Yes, there's a broad spectrum of corruption, but anytime someone has a lot of money at stake and that money is ultimately the disbursement of that money or control of that money goes through one or two people, whether it's a city councilman in LA, who there's 14 city council members in a very large city. That means each council member wields a lot of power.
Sure.
And so I think there's certainly some structural evaluation to be had, but it puts so much emphasis on an individual person and individual decisions that sometimes I think the cost of doing business is perceived for a either developer or wannabe corrupt developer is, either everyone else is doing it, or, if I just get this person on my good side, it's going to really open things up for me. So it's worth it to take a shot. If you find a willing or tempted, and to use your Lord's Prayer reference, tempted politician, unfortunately, it can make a big difference until you get caught, which often they do.
Sure. And of course, we have appointed public officials under our systems of city government. A lot of times it'll be a city manager or development director a utility director who has the ability to issue a no-bid contract up to a certain level. Do you find that some of the folks who are seeking those contracts sometimes try to feather the decision maker's nest?
Yeah, can you repeat the last part? It broke up on my end.
Well, if you have a contractor who wants to pave some streets and there's a particular individual in the city government, not necessarily elected, who has the authority to issue those contracts, do you find they get rewards or bribes?
I think it certainly makes them a natural target of both of those things. Rewards, bribes, people cozying up to them and potentially crossing the line and blurring the line of what is, what we call, it's okay to try to curry favor with someone, but you cannot pay people intending to influence them on an official decision. But yeah, people identify who that decision maker is, and particularly in LA City Council, and also where there's these committees, where there's a chair of the Planning and Land Use Management Committee who has a lot of authority over, what gets built, what contractors can do, what permits.
Can I ask you if you're speaking on behalf of the Department of Justice, or are you talking about your role and your personal history?
Well, I'm appearing on behalf of the U.S. Attorney's Office in my official capacity. My personal views are my own and do not reflect the views of the Department of Justice or the U.S. Attorney's Office for the Central District of California. Thank you, Stu.
Well, you're very welcome. Now, we had been talking about the ways that appointed public officials as well as elected public officials locally can get into trouble with permits or issuing contracts. I did want to get to the recent Supreme Court case of Snyder versus the U.S., where the Department of Justice actually got overturned in a conviction, sadly, I thought, from my personal perspective, where a mayor, I believe it was in a town in Indiana, had issued a couple of $1 million in contracts to a company that was selling garbage trucks. And somehow he got a $13,000 check afterwards. Can you talk a little bit about that case and what it did and how it came to pass and how it's changed your activities?
Sure. Well, the department disagreed, and that's why they took it to the Supreme Court and believed that that statute, it's 18 U.S.C. 666, the one we referenced earlier, it has been for decades conceived to prosecute or to criminalize two forms of illicit benefits to politicians. One being traditional bribery. And by traditional bribery, I mean I am going to pay you $10,000 so you vote yes for my company.
Right.
That thankfully is still very much illegal. The second part of 666 is that it previously criminalized what we called gratuities, which is sort of a legal fancy way of saying gifts, where it also criminalized sort of the basically what you just described. A politician does something incredibly beneficial to some constituent, and the constituent doesn't say, I'm paying you in advance or for that vote, but as soon as the vote happens, awards him $13 million, $1,000, whatever the benefit is, as a reward for that exercise of official power.
And the statute says bribe or a reward, which is why I thought it was a very short-sighted ruling by the U.S. Supreme Court, because, wink, wink, will you do this for me? And then all of a sudden a check arrives after you've done it.
That's exactly right. Because unfortunately, most of our cases do not involve a contract for bribery, meaning that these days there's not, I will do this if you do that, sign on the dotted line, here's my thumbprint. Sadly, we don't get to prosecute those cases because criminals, although they're often joke that criminals aren't the smartest, in public corruption, they often are among the smartest. And so we don't have a lot of that evidence.
They're manipulative and sneaky, I think. Yeah. We are far from your office is in Los Angeles. On a good day, it's a 5-hour drive.
It's a nice train ride, though, Stu.
It is a nice train ride, as a matter of fact. We'll talk offline about that. Are there some ongoing investigations in the county of San Luis Obispo? I've seen some pleadings in the PB case, and I don't want to get into anything you can't talk about, but I've seen pleadings in the Pettit, Mr. Wright prosecution that suggests that there are, quote, widespread ongoing investigations into corruption in San Luis Obispo County and its cities. Is there anything that is going to come up soon?
So the fun part about my job is I can't talk about the fun stuff often. So any ongoing investigations, unfortunately, in order to protect the integrity of them and also not to improperly influence potential witnesses or jurors, I can't talk about.
That's okay. I had to ask.
Of course.
The last thing I wanted to address was, when Adam Hill had his home and his official office searched, it was just a few days after he had been reelected, after the vote certifying that he had been reelected to the supervisor's office occurred. And I think a lot of people thought that if that information had occurred before he was elected, he probably wouldn't have been reelected, and the person who was running for that seat against him would have ended up in the supervisor's office. I know the Department of Justice has a rule that they try not to bring prosecutions within 60 days before an election. Is that right?
Yes and no, and also it changes with administrations.
Oh, does it? Okay.
It does, although there are long-standing rules about what we call election interference policy,
right,
which is essentially what you just described. And to be as candid as I can in an interview, there's not a perfect solution, because if you do something too close to an election that interferes with that election in a way that, say, Adam Hill doesn't get elected, but then it turns out somebody was wrong or
Sure.
it was different, and that someone's incorrect assumption or allegation improperly influenced the vote, then we're in a different situation, but sort of equally harmful, as if you have information, which we sometimes do, hold it if it's too close to an election, and then make an announcement or an enforcement action after the election, so as to not interfere with it before. Generally, the idea is that then other actions can take place. People can get impeached, people can resign, and people will know the facts then, or they're prosecuted and convicted and sentenced to prison or resign as a part of that process. There's sort of more options afterwards than there are before if you go too early.
Okay.
And also, it is often the case that in cases like this, everyone wants to dot their I's and cross their T's and not rush to a public charge. And electoral interference policy also involves doing search warrants or other overt actions that would suggest someone's under investigation too close to an election.
Okay.
I believe it's all well-intentioned, but like many things in government, it works better than others sometimes.
Sounds like it's not a hard and fast rule to me.
There's a hard and fast rule with differing dates of when, 60 days, 6 months.
Okay.
It depends. But
right.
There is a hard and fast rule, just where that rule falls is sometimes.
Well, we only have a couple seconds left. This 60-day rule, does that go to the election day, or does that go to when California issues its ballots 29 days before the election?
The election day.
Election day. Okay. Well, that's good to know. Well, folks, you have been listening to SLO County Public Policy and the Law and my interview with Mack Jenkins, the Assistant U.S. Attorney in Los Angeles for the Criminal Division.
For more information on SLO County Public Policy and the Law, visit our website, knews985.com.